Welcome back. It's time to look at the vocabulary words for week 6. We're talking about the court system this week, and so the first 4 terms have to do with juries. The first term is the word jury itself. A jury is a group of people selected by both sides of the case to determine what happened and to decide who is guilty in a criminal case or who is liable in a civil case. Typically in Hawaii, a jury is composed of 12 people. The process of selecting the individual jurors is called voir dire. The voir dire, or jury selection process, requires the individuals who have been called to court for the jury pool to answer specific questions by the judge and both sides' attorneys. Each side wants to have a jury that looks like this. So each side is allowed to excuse or eliminate jurors whom they feel are going to be too biased. There are 2 special terms that refer to the objections that one side can make to the potential jurors. These 2 terms, or objections, are called for-cause challenges and peremptory challenges. A for-cause challenge is made when the attorney feels that the juror has a personal bias towards his or her client. For example, if the potential juror is a friend of the plaintiff, it's likely that the person will be biased against the defendant. The defense attorney can make a for-cause objection to the court, and based on the friendship, the judge will excuse the person from serving on the jury. A for-cause objection can be made by the defense counsel, the plaintiff, or the prosecution. So anybody can make these for-cause challenges. The other type of challenges is called a peremptory challenge. A peremptory challenge is the opposite of a for-cause challenge. It allows one of those attorneys to eliminate a juror from the pool without having to give a reason. The attorneys use a combination of the for-cause and the peremptory challenges, as discussed in the lecture this week, to help us select a jury that they feel will be sympathetic to their client. The next vocabulary term is case in chief. This term refers to each side's primary argument. In a civil case, the plaintiff always has to present his or her side of the case first, and all of their evidence is called the plaintiff's case in chief. After the plaintiff or the prosecution has presented all of their evidence, the defendant goes next with their case in chief. The last vocabulary word is jury instructions. I included this term because it's normal for most people to assume that jury instructions are the information given to the jury ahead of time on how to behave in court, such as paying attention to the witnesses and taking good notes. However, this is incorrect. The term jury instructions refers to the information that is given to the jury after the plaintiffs and the defendants have presented their cases, but before they go into the jury room to make their decision. The jury instructions will tell the jurors what the law is that they need to apply to the facts and the testimony in the case. We'll be talking more about the trial process in this week's lecture. See you next week.